What's going on YouTube? Listen up, young elder gang. This is Joe Blow, at you with another banger. Please make sure you like, subscribe, and share this video, fam. I hope this video get at least 100,000 likes. In this video, you will find history, definitions, scripture, information, and best of all, what we Americans have been deprived of from the beginning, the truth. Keep in mind, this content used in this video is intended for entertainment, educational, and informational purposes only. The information provided on this video is not to be construed as legal advice. We are not legal attorneys. For legal advice, please seek out a licensed legal advisor or attorney. We will give you the total truth as we best understand it today. Be sure to hit that like button, young elder gang. Hit that subscribe button if you're new to the channel. Hit that bell and don't forget to check back with us every day for new content. Alright, let's get started. Stopping illegal attacks. Welcome. In this video, I want to show you a simple, fast way to stop illegal attacks. Keep in mind, a court is a place where games are played. You play tennis on a tennis court, you play basketball on a basketball court. In their court systems, which are really auction blocks, if you don't know which game they're playing, you will get served. A legal attack is an act that causes someone to reasonably fear harmful or offensive contracts. In other words, when someone is trying to sue you in court. Now, we're talking about something where they're coming after you for something. Maybe criminal, child support, tickets, simple attacks. Something where an agency, government program, or maybe an opposing attorney is simply coming after you with a legal attack. This isn't for something where there might be a dispute between two private parties. This is really more of an institutional attack against you. So just keep in mind, typically, most people when dealing with court situations are gonna try to make things complex for themselves, and that's really where they get you. They trip you into this complex system. We're going to show you a very simple system. This will only take a few minutes to explain, and it literally takes less than 60 seconds to say a couple of times, but of course in the back and forth of the court, it may take a few minutes, but you have to stay focused. So remember, these corporate courts have no authority until you grant it to them. If you are new to the game, then the information process as presented in this video may be shocking and a little strange to you. We understand that it will be a leap of information that you have never been exposed to. Maybe you've experienced your government, or were stomped on and railroaded in court, or robbed, pillaged, or plundered by an attorney, state agency, or even the IRS. Maybe you believe constitutional due process and fairness still exists in the law, in the courtroom. Maybe you believe that everything is the way it's supposed to be. They say jump, and you ask, how high? You look around and aside from the negative TV news at 6 p.m., you just don't see anything wrong. Maybe you've not recognized the glitches in the program. Well, better snap on your seatbelt, people, because things have changed, and where you're going, there's no turning back. No one told you that court proceedings are purely administrative and not judicial, as the organic constitutions, state and federal mandate. In these administrative proceedings, why is it that these so-called courts do not explain the nature and cause of the action, never prove jurisdiction, and never allow you to have counsel of your choice, and never ever allow the jury to decide the law in a case trial? Maybe those administrative tribunals are not constitutional judicial courts of due process. Welcome to America, or should I say, Mystery Babylon. The artificial world. Keep in mind, the artificial world is de facto or colorable, while the real world is de jure or black and white. All commercial enterprise by living souls are performed through their corporate entities, or strawmen as frontmen. Since the government has the highest legal title to these strawmen, all commercial activity is presumed to be controlled by Babylon, and hence taxed to Babylon. It is by this mechanism that the Babylonian system draws out the commercial energy of every living soul. Romans 12, 1, 2. I beseech you therefore, brethren, by the mercies of God, that ye present your bodies a living sacrifice, holy, acceptable unto God, which is your reasonable service. And be not conformed to this world, but be ye transformed by the renewing of your mind, that ye may prove what is that good and acceptable and perfect will of God. We are to present ourselves, not be represented, or as more commonly seen, represented in court by an attorney, who is there only to represent the corporate fiction in the administrative unit, court, to administer the bankruptcy and the pledges of the property to the state, and to take the revenue from the debtor slaves of the plantation. Luke 11, 46, 52, and he said, Woe unto you also, ye lawyers, for ye laid men with burdens grievous to be borne, and ye yourselves touch not the burdens with one of your fingers. Woe unto you, lawyers, for ye have taken away the key of knowledge. Ye entered not in yourselves, and them that were entering in ye hindered. This pretty well speaks for itself. What is no authority? The absence of authority means that people are not obligated to obey the law, or that state agents are not allowed to force others to do something. Here are some other definitions related to authority. Unauthorized, without permission or authority to do something or be in a certain place. For example, unauthorized personnel are not admitted beyond this point. Non-authority, something that a court would not use to make a decision. Authority, the power to make decisions or give orders, or the right to control or direct someone or something. For example, only department managers have the authority to change the schedule. Self-assurance, the expertness and self-assurance that comes with experience. For example, the pianist's performance lacked authority. How do you grant the court jurisdiction over you? You can grant the court authority over you in a civil case by filing a lawsuit, which is a way to establish personal jurisdiction. Filing a lawsuit. When you file a lawsuit, you are agreeing that the court has the power to make a decision that affects you. Consent. You can give your consent to the court's authority in a few ways, including express consent, you appear in court and submit to the court's authority. Implied consent, driving on a state's roads with driver license is an example of implied consent. Personal jurisdiction is the court's power over a person or entity involved in a case. This includes the court's power to make judgments that affect the person's rights. What is a volunteer strawman? They require you to volunteer for them. If you don't know that concept, look into some of our other studies on that issue in the law school playlist. But the bottom line is, they don't have the authority over you unless you've harmed somebody, and until that's happened, you have to voluntarily go into some sort of contract arrangement with them. A volunteer in law is someone who performs services for a public agency or organization for civic, charitable, or humanitarian reasons without receiving compensation. Volunteers are not employees, and they can come and go as they please. What is a straw man? The straw man, as defined in Black's Law Dictionary 6th edition, is a front, a third party who is put up in name only to take part in a transaction. Nominal party to a transaction, one who acts as an agent for another for the purpose of taking title to real property and executing whatever documents and instruments the principal may direct respecting the property. Person who purchases property for another to conceal identity of real purchaser or to accomplish some purpose otherwise not allowed. Yes, volunteers can sue a nonprofit organization if they are injured or harmed due to the organization's negligence. Volunteers can also sue for property damage, emotional distress, or damage to their reputation. The Volunteer Protection Act, VPA, of 1997 protects volunteers from civil liability in most circumstances. However, the VPA does not protect the nonprofit organization from liability. The Volunteer Protection Act protects volunteers under many circumstances, although it does not eliminate the possibility of a lawsuit. It does not shield the nonprofit or governmental agency using the volunteers' services from liability. It only protects the volunteers themselves. To sum it up, a volunteer strawman is someone who agrees to be a part of the fictional system. Where is the contract? So, what we want to do, though, is to stay respectful, but be firm. Treat your honor, with all due respect. You might just get a better, wish granted to you if you do. This is one of our angles. We're not there to fight the judge. We're really there to fight against the party bringing it against you. We will get into how to deal with the judge later. Okay, so keep that always in mind. They're presuming these contracts that simply don't exist. If you really look up the origin of it, equals no. We're going to be doing a lot of studying on the breakdown of language here in the future, but that means there is no contract, just by their presumptions. Now, this does not require knowledge of statutes and codes. It's just one simple procedure. Statutes and codes are so-called laws written and enacted by the legislative branch of government. Most new laws are created through statutes. Codes are a subject-based arrangement of laws passed by a jurisdiction's legislature. Codes are well suited for research because they bring together all of current laws on a given subject. Like we said, it could be traffic, criminal, or child support. Even a lawsuit by a third-party debt collector, a tax agency, could be the grass cops or the building inspector. Who knows? Whoever is bringing in some authority, saying they have authority over you, you have to challenge that authority. This is not, like we said, for dispute between individual parties, but put all the burden of proof on the accuser. The burden of proof in a legal dispute lies on the party who makes the claim, or the accuser. In civil cases, the plaintiff, or the person filing the lawsuit, has the burden of proving their case. the plaintiff must prove that the allegations are true and that the defendant caused damages. The plaintiff must usually prove their case by a preponderance of the evidence, which means that it's more likely than not that the defendant caused harm. However, more serious civil cases may require clear and convincing evidence. In criminal cases, the burden of proof lies on the prosecution and the defendant is presumed innocent. The prosecution must prove beyond a reasonable doubt that the defendant carried out the criminal act. The burden of proof is also known as the onus of proof. The Latin maxim semper necessitas probandi incumbit aequi agit translates to, the necessity of proof always lies with the person who lays charges. Conditional acceptance. Keep doing this, you've got to constantly asking questions and overstand conditional acceptance. Conditional acceptance has multiple meanings, including a response to a college application and a legal term. A conditional acceptance is a legal term that refers to a response to an offer that changes or adds to the original terms. This is considered a counteroffer, not an acceptance, because it alters the original terms. An offer is a proposal to enter into a contract where one party, the offerer, communicates terms to another party. The offeree, elements. An offer must be legal, made with the intent to be bound, and include reciprocal obligations. Communication. The offer must be stated in a way that a reasonable person would expect to result in a binding contract if accepted. Acceptance. The offeree must unconditionally agree to the terms of the offer before it is withdrawn or lapses. Acceptance can be implied through words or conduct, but silence usually doesn't count. Withdrawal. The offerer can usually withdraw an offer before it's accepted, unless the parties have created an option contract. Rejection. If the offeree rejects the offer, it can't be accepted later. An offer is a key part of contract negotiations and the start of the contract process. Once an offer is made, the offeree can accept, negotiate, or reject it. The contractual nexus. Since everything operates under contract or agreement, understand that pursuant to a contractual nexus between you and the social compact party states known as the state of whatever of the United States and/or the United States of America, you have no rights as clearly stated within their so-called judicial case law per Paddleford, Fay, and Company versus the mayor and alderman of the city of Savannah, 14 Garrett 438, 520, 1854, a private person, man, is not a party to the U.S. Constitution, which is the compact contract for the public servant bound by their oath of office. So if you are not a party to the social compact contract known as the Constitution, how do you become liable to some so-called federal agency or state and their rules and regulations? If not due to the fact one may be a federal employee, then maybe you consented. The same applies to the state. If their forefathers created their agency government in valid contractual concept and principle, would you think they were so ignorant that they would place themselves within the contract designed only for their servants? However, take notice that you have no contract with any social compact or construct, otherwise called government, to bargain for your rights, let alone to secure your rights in the second place. Is that why you are robbed, pillaged, and plundered by their so-called government and their corporations that they create? The proper party. So, like we said, keep asking questions. Say, does that apply to me, or I'll accept that if you can prove it applies to me. That's a conditional acceptance, so keep that methodology in mind. We're always putting the burden of proof on them, so this can be done in writing or in person. This technique could be used. A lot of our friends and family have had a lot of success with multiple cases with this technique. So, on the ticket or the document, the letter, the bill, or whatever it is they're trying to sue you, you're going to direct the attention towards the party bringing it to you, that agency or that individual. We're really not going to go after the judge. We want them on our side, but we want to direct it towards the proper party and get their support. This is really to the party dragging you into something, okay? So you could write this like maybe you get a ticket or an indictment or something. That's come to you as a delivery to your door. The first thing you should do is respond with something along these lines. Now this might slightly change, but don't add much to it. Keep it simple. The simpler the better. If I was in court or you were in court, you might have to stand up and say something, but you could simply write something to this effect if it's just on the document. You might have to do both. You might have to write on it and still show up and do it again in court. Don't be afraid to do something very simple. When they call you up, you say, I'm here on that matter, but before we can proceed in this matter as director and beneficiary of my legal person and corporation. You have 21 days to respond in writing and provide proof of claim with evidence that you have legal and lawful authority as my public servant to bother me at all. You could put it in slightly different words if you're trying to be polite, but generally speaking, you need to be that blunt. Don't be scared of the pirates. Don't go in there half-cocked, make sure you've got your ducks in a row. You know how they like to play crazy. They would go on, they'll say, well, we're here to enter a plea. We're here to do this or that. What's this sort of thing you're bringing up here? Acting like they don't know what's going on. Keep in mind they are pirates and privateers. They're gonna say everything except answer the question, usually, hold your square, stand for something, or you will fall for anything. Stay calm. Then you simply say, well, excuse me, but you know, until this issue is addressed, we cannot proceed. I mean, can we? I need to know if you have the proper authority. I'm not challenging whether the court has the authority to hear this matter. I'm challenging the individual bringing it to me. The court gets ticked off when you challenge their corporate courts, but challenge the party bringing it to the court. This is one angle we've been working them from, you know, these mercenaries. So don't fall for their tricks, and the court will try to pull you off your position. They're gonna go off to other issues. They will try to say, we're not here for that or whatever. You just simply keep coming back to it. Don't let them proceed without addressing the issue. Well, Your Honor, I really don't understand. Keep in mind, we're using that word understand very carefully, because it means I don't agree without arguing, Your Honor. I really don't understand, and isn't there a matter I've raised that still needs to be addressed? How can I enter a plea or proceed until this is answered? So, with all due respect, there is a matter I've raised, which needs to be addressed. Then repeat the statement. Just keep repeating the mantra that we just gave you. They may test you 3 times if you didn't know this. The Wizard of Oz was actually instruction on how the new legal system was going to work after 1933, after the bankruptcy. Many films have been made that actually have very important messages in them, not by accident. They said, Dorothy, you could have gone home anytime you wanted, just click your heels together 3 times and you can go home, and that's what she did. So they may test you 3 times. Be prepared for them to ignore it, act like it's stupid or crazy. You know, try to make you go away and come back, sit you down and bring you back later. Whenever this happens, you start over again. Go right back to the same message. 3 times is a charm sometimes. So again, I do not understand, nor can I consent to proceed until they answer and provide evidence of authority. You're not just asking him to tell you that there's a statute. You want the evidence of authority. Then repeat yourself. Address the prosecutor or the attorney coming against you, okay? Before we can proceed in this matter as director and beneficiary for my legal person or corporation, you have 21 days to respond in writing. By the way, memorize this. Say it a few times until you can say it in your sleep. Before we can proceed with this matter as director and beneficiary of my legal person or corporation, you have 21 days to respond in writing and provide proof of claim with evidence that you have legal and lawful authority as my public servant to bother me at all. Until then, I cannot consent to proceed. Do you understand? And again, keep directing this at the party bringing the matter against you. Keep saying this. You can do this sort of in writing and in live situation or both. Be prepared. It won't be hard for you to memorize these simple lines. Make sure you stay on script, okay? Then if you want to go into situations like subrogation. Subrogation is the process where one party assumes the legal rights of another, typically by substituting one creditor for another. Subrogation can also occur when one party takes over another's right to sue. We will teach more on subrogation later. We've discussed that with our students. We've had a lot of success with that. That's a little more complex, where you talk about not being the trustee or the beneficiary. A beneficiary in the broadest sense is a natural person or other legal entity who receives money or other benefits from a benefactor. For example, the beneficiary of a life insurance policy is the person who receives the payment of the amount of insurance after the death of the insured. In trust law, beneficiaries are also known as cestui que jus, where they're bonds. You could bring forth the silver bond. So, there is different techniques that we've also discussed in our law school playlist, but again, you need to have that as your plan B. But this is your initial salvo whenever you get into one of these situations. Start with this first, then bring in those techniques as it moves forward if necessary. Hopefully you don't have to, but both of these things is a 1-2 punch. This simple jurisdictional challenge, which is what this is, plus the subrogation behind it, should help you deal with the vast majority of the situations coming against you. You'd be surprised of how simple it is. If you start arguing, debating, and trying to prove something, it's over. You're now just enter into their court, game on. You've now just put yourself under their jurisdiction. So if you want to get more training like this, go to our playlist called the Young Elder Law School. Remember, don't be incompetent, meaning not having or showing the necessary skills to do something successfully. Be sure to hit that like button and subscribe button for more videos like this. I thank you for taking your time to watch this video. We'll see you guys later. Peace.